Hello, everyone. We can now start going to the chapter of Rule 16, request for further particulars. The former request for further particulars in terms of Rule 15 to enable the defendant to plead has fallen away. The plaintiff must plead full particulars of claim in the combined summons and/or declaration. If that has not been done, the defendant may apply to set aside the summons as an irregular proceeding or accept to it. Further particulars may be requested after the close of pleadings, not less than 20 days before the trial. Such further particulars are strictly necessary to enable him or her to prepare for trial. The particulars must be delivered within 10 days after receipt thereof. If a party who has been requested in terms of this rule to furnish any particulars fails to deliver them timelessly or sufficiently, the party requesting the particulars may apply to court for an order for their delivery or for the dismissal of the action or the striking out of the defense, whereupon the court may make such order as it deems fit. A court shall, at the conclusion of a trial, be removed to consider whether the further particulars were strictly necessary. And it shall disallow all costs flowing from any unnecessary request or reply or both, and may order either party to pay the cost thereby wasted on a legal practitioner and client basis or otherwise. Rule 23, discovery of documents. The discovery of document was stated in the case of Beck versus Fairway, it is a 1949 case, to ensure that before the trial, both parties are made aware of all the documentary evidence that is available. By this means, the issues are narrowed and the debate of points which are incontrovertible is eliminated. What is the purpose of discovery? Discovery is a procedure whereby a party to an action can require his opponent to specify on oath the documents in his possession under his control which relate to the action. Subrule 23, subsection 1 lies. Inspect and copy of such document. Subrule 6. Discovery is a procedure relating to preparation of trial and the procuring of evidence. Any party to the case may require the other party to make discovery within 20 days. When a party is required to discover, he must file an affidavit and annex 2 lists. The first list must contain those documents in respect of which no privilege is claimed, and setting out what document is its date, and if it is original document or a copy thereof. The second list contains the document in respect of which the privilege is claimed, communications between legal practitioner and client and advocate, witness statements, and advices to clients are privileged documents, etc. Discovery must be made of all the documents relating to any matter in question in such an action. Some practitioners seem to adopt the attitude that they will not discover if they have not been asked to do so by way of Rule 23. Non-compliance with the request of discovery in terms of Rule 23. If a document has not been disclosed as requested in terms of this rule, it may not, save with the leave of the court, granted such terms as to it may seem meet, be used for any purpose at the trial by the party who was obliged but failed to disclose it before the trial. Timeous discovery is essential for proper preparation for trial. The legal representative of the party to whom are the documents discovered with those in his possession. Consult with his client and witnesses in connection with the discovered documents and to decide whether the court should be approached to order further and better discovery. In ordering compliance with this rule, the court may make an appropriate order as to costs, including an order that the respondent pays the costs of the application on a scale between legal practitioner and client. If a party fails to give discovery after he has been requested to do so, the party desiring discovery may apply to court in terms of Rule 23, Section 8. The court may order compliance, may dismiss the claim, or strike out the defense. Rule 24, medical examinations. Any party to proceedings in which damages or compensation in respect of the alleged bodily injury is claimed shall have the right to require any party claiming such damages or compensation whose state of health is relevant to the determination thereof to submit themselves to medical examination. Any party requiring another party to submit to such examination shall deliver a notice specifying the nature of the examination thereof, the person or persons by whom it will be conducted, the place and the date, not being less than 15 days of such notice and time it is desired that such examination take place. And requiring such other party to submit himself or herself for examination at such a place, date and time, this notice referred to shall state that the other party may have his own medical advisor present at such an examination. Any party receiving such notice within 10 days of the service thereof notified the party delivering it within the nature and the grounds of any objection which he may have any party to such an action may at any time by notice in writing require any person claiming such damages to make available insofar as she is able to do so to such first mentioned party within 15 days any medical report, hospital records, X-ray, photograph, or other documentary information of a like nature relevant to the assessment of such damages or compensation in terms of Rule 24. Subsection 1, 2, subsection 4. If the party objects to the place, date, and time, an alternative place, date, or time must be suggested. Inspection of things while preparing for trial. If it appears that the state or condition of any property, whether movable or immovable, may be relevant with regard to the decision of any matter at issue in any action, any party thereto at any stage, not later than 15 days before the hearing, give notice requiring the party relying upon the existence or condition of such a thing, it may in such notice require such party to have such thing or a fair sample thereof available for inspection or examination for a period of not exceeding 10 days from the receipt of the notice in terms of Rule 24.7. Let's look at expert witness. No party may call an expert witness unless he has delivered two notices. The two notices may be combined in one document. A party who wishes to call an expert witness should have delivered a notice of his intention to do so, not less than 15 days before the hearing, who the expert is and the nature of the expertise. Not less than 10 days before the hearing, have delivered a summary of such opinion of the expert and his or her reasons, therefore. In the case of Coopers versus Judge, it's a 1976 case, sets out the meaning of the words opinions and his reasons, therefore, at page 371. In the context in which the phrase reasons, therefore, is used in Rule 24.9, it means, or at least includes, the facts and data on which the opinion is based. The facts and data would include those facts personally or indirectly known or ascertained by the expert witness from general scientific knowledge, experiments, or investigations, or by others, or information from textbooks, which are to be duly proved at the trial. However, summary also governs his reasons, therefore, as the testimony that the expert witness intends to give need not to be fully set out in the summary. Tendering in evidence any plan, diagram, model, or photograph. In terms of Rule 24.10, provides that any party who wants to use plans, diagrams, sketches, models, or photographs at the trial must give 10 days notice prior to the trial of his intention to do so. A notice which shall state that every party receiving it shall be entitled to inspect the plan, diagram, model, or photograph, and shall require such party within 5 days of the receipt thereof to state whether he or she has any objection to such plan, diagram, model, or photograph. If no objection has been made to the notice, the particular photographs may be used at the trial without further proof thereof. If a party receiving a notice objects to the admission in evidence, and it must be proved at the hearing of the action, if the party receiving the notice may be ordered to pay cost of such proof, it should be noted that if the above preparation for trial does not be completed at the trial date, may not be allocated, and the trial date has not been completed, a trial date may not be allocated by the court in terms of the notion of that as the matter is to be trial ready before being allocated a date of hearing. Rule 26. Subpoenas, interrogatories, and commissions dependent essay. Any party desiring the attendance of any persons to give evidence at a trial may, as of right, issue a subpoena for that purpose, each of which a subpoena shall contain the names and not more than 4 persons, and service thereof upon any person therein named shall be effected by the sheriff in the manner prescribed by Rule 9, and the process of subpoenaing such a witness shall correspond substantially to Form 24. To ensure that all necessary witnesses attend the trial of an action, subpoenas must be issued and served timelessly on all the witnesses. Subpoenas are served on witnesses even if they promise to faithfully be there without service or subpoena, to avoid explaining to the court why we have not issued a subpoena. Subpoena, this is if a witness has in his possession or under his control any deed, instrument, document, or object which the party requiring his attendance desires to produce in evidence, the subpoena must specify such document or object and require him to produce it at the trial. Such a subpoena is called subpoena juris tecum. Such a witness shall hand over the deed to the clerk of the court or register as soon as possible, and thereafter the parties may inspect it and make copies of it. Rule 25, pretrial procedures, formulating issues. The request in writing referred to Section 54 of the Act shall be made in duplicate to the registrar or the court, requesting the court to call for a pretrial conference, and shall indicate generally the matters which it is desired should be considered at such conference. Section 54 and Rule 25 create the authority and procedure in the magistrate court to arrange pretrial conferences in order to promote access to the courts, or when it is in the interest of justice to do so. A court may order or may at the pretrial conference dispense with any provisions of the magistrate court rules and give discretion as to the procedure to be followed by the parties so as to dispose of the action in the most expeditious and at least costly manner. See also paragraph 4.4 of the Civil Practice Directives for the regional courts in South Africa, which deals with pre-trial conference in the regional court. A pre-trial is an important method of ensuring case flow management and to see that the matter is trial ready. This prevents many unnecessary postponements of trial and can save parties a great deal of wasted costs. Section 54, the pre-trial procedure for formulating issues. The procedure set out in this section is intended to provide a cheap and expeditious method of settling before the magistrate in the chambers preliminary and ancillary points of procedure and evidence as set out in Section 54. This will have the effect of lessening the costs and shortening the duration of the cases in the court. The following can be considered during the pre-trial: the simplification of the issues, the necessity or desirability of amendment to the pleadings, the possibility of obtaining admissions of fact and of documents with a view of avoiding unnecessary proof, the limitation of the number of expert witnesses, such other matters as may aid in the disposal of the action in the most expeditious and least costly manner. Rule 27, withdrawal, dismissal, and settlements. Subrules 6 to 10 were introduced to avoid disputes as to whether or not there had been a settlement and as to how it had come to be accepted by the court. It is therefore desirable, in order to avoid such dispute, that the subrules should be adhered to. Settlement agreement should settle all disputes, outstanding matters between the parties. The agreement should be worded clearly in the understandable languages. Ask the client to read the agreement and sign it himself or herself. If a settlement is simply recorded and the party who must comply with the settlement defaults before the other party can enforce the settlement, an application in terms of Rule 27(9) must be brought. The settlement has been made an order of court and the other party who has to comply defaults, the other party can simply proceed with the request of warrant of execution from the clerk or the register of the court upon production of usually an affidavit. Once the matter has been settled and the deed of settlement drafted and signed, you may approach the court to record the settlement and make the settlement an order of court in terms of Rule 27, Subsection 6. Rule 27 deals with the 4 distinct procedures: the withdrawal by a plaintiff of his action or by an applicant of his application, the abandonment of either any party or party to a particular claim, an exception or defense pleaded by him or her, an application by the defendant on dismissal of an action if the plaintiff delays in giving a notice for trial, the recording by the court of any settlement arrived by the parties to an action. Rule 12, judgment by default or default judgment. In terms of Rule 12 of the rules, it deals with default judgments. In the regional court, civil practice directives 7 applies with regard to default judgment on damages claims when dealing with default judgments in the regional court. Please have the reference to this directive. It should be noted that the different courts have different requirements to be adhered to before granting a default judgment. Please acquaint yourself of your local court requirements. Basis of default judgment. The basis of a default judgment is a deemed admission of the claim by the defendant. This is obvious from both the warning contained in the summons and the following dictum of Boshoff in the case of Parties Engineering versus Fendi Spares, the 1962 case. The defendant is in default, and it is reasonable to suppose in the majority of cases that he is not disputing the claims nor the amount thereof. When may a default judgment be granted? The rules of the court for the magistrate courts provide for the grant of default judgments in 4 circumstances. Rule 12 provides for a default judgment to be granted in 2 instances. Rule 12(1)(a), there are 2 requirements for the grant of a default judgment in terms of the subrule. The defendant fails to enter a notice of intention to defend within the time limits specified in the summons or before the plaintiff lodges his or her request for judgment by default, and the defendant has not consented to the judgment. In terms of Rule 12(1)(b), the procedure in Rule 12(1)(b) applies where the defendant has failed to deliver his or her plea timelessly. The requirements for a default judgment in such a case are the following. The defendant has entered appearance to defend. She fails to deliver his or her plea within specified time in terms of Rule 17 or within the extended time allowed. Plaintiff has delivered a written notice calling upon the defendant to deliver his plea within 5 days. The defendant has failed to deliver the plea as notified. And Rule 12 provides that if the defendant fails to deliver the plea within the time limit, he shall be default with such a plea and ipso facto barred. Basically, this is a notice of bar, so the defendant shall be barred accordingly. It was held in Thornhill versus Gerhardt, and it is a 1979 case that service upon the defendant using the address of the notice of the withdrawal was not proper and that a judgment could not be granted on the basis that the defendant default in such a case. When may a judgment by default be granted? Judgment by default in terms of Rule 32, Section 2, the matter has been set down for trial or postponed to a specific date for trial, and the defendant fails to appear on the date of the set down for trial. Before relief may be claimed under Rule 32, Section 2, the matter must have been properly enrolled for trial to apply for default judgment if the defendant fails to appear on the date set down for trial. The case of Van der Post versus Magistrate of Rehoboth, it's a 1924 case. A defendant is not absent within the meaning of Rule 32 if he or she is personally absent, but his or legal representative is present. Request for default judgment. Request for default judgment in the case of applications of default judgment in terms of both Rule 12 and Rule 12 1B or 1A. Plaintiff must lodge a written request for judgment in duplicate together with the following documents: the original summons, the original return of service. Please note that if an application for default judgment is lodged in respect of an action based on a liquid document or any agreement in writing, the plaintiff shall, together with a request for default judgment, file the original of such document, any other agreement in writing or an affidavit setting out reasons to the satisfaction of the court or the register or the clerk of the court why such original cannot or should not be filed in terms of Rule 12, 3A, and Rule 12, subsection 6. Judgment may be requested for Rule 12, 1A, any sum not exceeding the amount claimed in the summons, any other relief claimed in the summons, the course of the action, interest rates specified in the summons to the date of payment, in the absence of such interest rates having been specified in the summons at the rate determined in terms of Section 1, Subsection 2 of the Prescribed Rates of Interest Act of 1975. Postal service of summons in terms of Rule 12, Subsection 3. The summons was served by a registered post as provided for in Rule 9, Section 3. The clerk of the court may not enter judgment by default unless the acknowledgement of receipt referred to in Rule 9, Subsection 13A has been filed by the sheriff with his or return of service. In connection with corresponding provisions in the old rules, it was held in Newman versus Iton that the acknowledgement of the addressee must be acknowledgement signed by the addressee himself. In the case, the clerk of the court had no means of knowing that the acknowledgement was not of the addressee once it was brought to the notice of the magistrate that the person who signed was not the addressee. The magistrate should have set aside the judgment. Unliquidated claims in terms of Rule 12, Subsection 4. When can we say a claim is liquidated or an unliquidated claim? In the matter of Fatis Engineering versus Fendi Express, when an amount is due upon a contract and the exact amount due is simply a matter of calculation from figures in the books, the claim is a liquidated one. When a contract of sale is concluded and there is no express agreement as to the price of the article, it is an implied term of the contract that a reasonable price will be paid for the article, that is to say, a price ordinarily charged by persons who deal within such articles at the time and place of the sale. Similarly, where a contract for rendering services is concluded and the parties do not agree to the remuneration to be paid, therefore, it is an implied term of the contract that a reasonable remuneration will be paid for such services. Such remuneration depends on what is regarded as reasonable in that particular trade or profession. In our organized society with businesses, trades, and professions organized as they are, it is normally a matter of no difficulty to determine the usual amount, market price of articles sold, and the reasonable remuneration of services rendered. These are matters which, as a rule, can be ascertained speedily and promptly. Procedure in terms of Rule 12, Section 4. The court may, in terms of this rule, require the plaintiff to furnish evidence, either viva voce or by affidavit, of the nature of the extent of the claim. Nature of the claim means no more than that the plaintiff shall, for example, where the unliquidated claim is the one for damages, furnish evidence of whether the damages arise from damage to property or from personal injuries. The rule does not require the magistrate to decide whether or not the cause of action has been proved, or indeed to apply his mind to any evidence relating to the cause of action. His sole duty was and is to assess the amount recoverable by the plaintiff and to give appropriate judgment. No purpose would accordingly be served in furnishing evidence, either oral or by an affidavit, in regard to the cause of action. The costs. If the defendant has not entered an appearance to defend, the costs are awarded on the undefended scale. Part 2 of Annexure 2 to the rules. Otherwise, costs are awarded on the defendant scale. In terms of Rule 12, may costs be awarded as between legal practitioner and client when default judgment is granted. It has been held in a long line of decisions that such costs may be granted if there was an agreement to the effect between the parties. The magistrate may not, even if agreed by the parties, grant an order for cost on the legal practitioner or on client scale. Default judgment checklist. When applying for default judgment, it is necessary to ensure that one's papers are in order in the following respects. Was the summons properly issued? Was the summons stamped by the clerk of the court on the date of issue? Was the summons signed by both the clerk of the court and the plaintiff or his or legal practitioner? Does the summons have a case number? Were all amendments to the summons initialed by the clerk of the court prior to the service? Are the parties properly cited in accordance with the requirements of Rule 6? Do the particulars of claim disclose the cause of action? Does the court have jurisdiction? The checklist details are further discussed until page 116, and I would advise everyone to, on their own time, to check the full details thereof. Rule 11, judgment by consent. Rule 11 provide for the consent to judgment. A consent to judgment is rarely required. If a defendant admits to the whole of the plaintiff's claim, he may merely pay the claim or make some arrangement of settlement without signing a consent to judgment in terms of Rule 11. According to Section 55A, for the purposes of Chapters 8, Recovery of Debts, and 11, I think, yeah, execution of this part of the Act, the factors a court must take into account when considering whether an order is just and equitable, include but are not limited to the size of the debt, the circumstances in which the debt arose, the availability of an alternative to recover the debt, the interest of the plaintiffs of the judgment or the judgment creditor, the rights and the needs of the elderly, children, persons with disability, and household headed by women. Social values and implications, the amount and the nature of defendant's judgment, debtors, income, the amount needed by the defendant or judgment's debtor for necessary expenses and those of the persons dependent upon him or her for the making of periodical payments, which he or she is obliged to make in terms of the order of the court. Agreement or otherwise in respect of his or her other payments, and whether the order would, in the circumstances of this case, be grossly disproportionate. Section 57 and Section 58. Section 57 is an admission of liability and to pay the debt in installment if any person in this section called the defendant has received a letter of demand or has been served with a summons demanding payment of any debt in writing, admit the liability to the plaintiff for the amount of the debt and cost claimed in the letter of demand or summons or any other amount. Offer to pay the amount of the debt and costs for which she admits liability in the installments or otherwise undertake on payment of an installment in terms of his or her offer to pay the collection fees for which the plaintiff is liable in respect of recovery of such installment, and agree in that the event of his failure to carry out the terms of his offer, the plaintiff shall, without the notice of the defendant, be entitled to apply for judgment in the amount of the outstanding balance of the debt for which he admits liability with cost, an order of court for payment of the judgment debt, and cost with installment for otherwise in accordance with this offer. The plaintiff or his legal practitioner accepts the said offer, shall advise the defendant of such acceptance in writing by registered letter. Section 58, consent to judgment and order for payment of debt in installments. If any person in this section called the defendant, upon receipt of the letter or demand of service upon him, or the summons demanding payment of any debt, consents in writing to the judgment in favor of the creditor, this section the plaintiff, for the amount of the debt and the cost claimed in the letter of demand and summons, or any other amount, the clerk of the court shall, on the return request of the plaintiff or his legal practitioner, accompanied by, if no summons has been issued, a copy of the letter of demand and the defendant's written consent to judgment. Enter judgment in favor of the plaintiff for the amount of the debt and the cost for which the defendant has consented to the judgment, and otherwise of the amount of the debt and cost in respect of which he has consented to the judgment order the defendant to pay the judgment debt and costs in specified installment or otherwise in accordance with this consent, and such order shall be deemed to be an order of court mentioned in section 65, section 1. If the defendant consent to an order of court for payment specified installments, the consent must set out full particulars of his or her monthly or weekly income and expenditure supported where reasonably possibly by the most recent proof in the possession of the defendant, other court orders or agreements, if any, with other creditors for payment of a debt and cost installments, and indicate the amount of the offered installment. Provisions of this section apply subject to the relevant provision of the National Credit Act, where the request for judgment is based on a credit agreement under the National Credit Act. That is the difference between the two procedures created by Section 57, the other created by Section 58. Section 57 provides for a written admission of a liability by the defendant and an undertaking to pay a debt by installment or otherwise, coupled with an agreement that in the event of his failure to carry out the terms of this offer, the plaintiff may refer the matter for judgment. Under Section 58, the debtor unconditionally consent to the judgment and the matter is immediately referred to the clerk of the court for judgment, and where applicable, an order of payment in installment procedure. Request for the default judgment under section 57 and 58 is done in terms of section 59, read together with rule 4, subsection 2. Form 5A or 5B is used. The request for judgment must be supported by an affidavit containing the evidence to prove all legal requirements have been met. The valid consent to judgment in terms of section 58 must be signed by the debtor and two witnesses whose full names, addresses, and telephone numbers are recorded. Rules which apply to section 57 and 58, sub-rule 12, section 6, requiring the original document. Rule 12, section 6A, requiring evidence of statutory compliance. Rule 12, subsection 7, requiring the clerk of the court or the register to refer an application for default judgment to the court. It has recently been held that a fair and effective collection procedure promote the purpose of the National Credit Act, provided that the provisions of Section 58, those of the National Credit Act, were applied properly with due regard to the parties' rights. The court has found that it was in the interest of credit providers, consumers, and of justice that the effective debt collection procedure offered in terms of Section 58 is utilized. In doing so, the court overturned a previous magistrate court findings that Section 58 was contrary to the purposes of the National Credit Act. It's in the case of African Bank Limited versus Yambu and others. It's a 2010 case. Now we get to look at application proceedings.